You proceed. Do you want to reserve some time?
Yes, Your Honor. 5 minutes.
Okay.
Morning.
Morning.
Please support. I'm Steve Brannick of Brannick Company Vernon, representing the appellant SHN. This case presents two distinct controversies. You've got parking easement controversy and you've got the fuel tank controversy. I'm going to start by diving into the parking controversy. So you've got three entities, Meta, Grill, and Marina, that are all sister corporations that are part of this development. In order to ensure that there's enough parking, Meta grants a parking easement over its property. That easement, according to paragraph 1, was perpetual. According to paragraph 4, it ran with land and specifically bound all successors and interests in that land.
So Meta is not mentioned in paragraph 7, and that's the gist of this, correct? That the successors and assigns don't apply with respect to Meta because they don't appear in paragraph 7.
Right. So that is the interpretational struggle that we're faced with here. I don't think it's a problem for a couple of reasons. First, I don't think there's anything inconsistent about paragraphs 1 and 4, which say that the easement runs with the land, and paragraph 7 that says that Marina and Grill successors are bound. Paragraph 4 talks about the effect of the easement on the dominant estate, and it says that easement runs with the land, so that it always attaches to
Your
the dominant
opponent
estate.
has argued that that's a boilerplate sort of throwaway phrase that we shouldn't necessarily put much stock in. What is your response to that?
Well, I haven't seen boilerplate. I mean,
I think
the heart of
there's
an
a-
easement is whether it's in gross, whether it only binds a particular person, or whether it's permanent. That's the most important provision in an easement. I don't think you can just dismiss that as boilerplate. So when you get to paragraph 7, it talks about the effect on Grill and Marina. Remember, that paragraph is focusing on the rights of the folks that have the dominant interest. And all it says that not only Marina and Grill do you get to enforce that easement that runs with the land, your successors and assigns get to enforce that easement. So there's nothing inconsistent about the two. And another important point is that paragraph 7 does not say that Meta is not bound. It just doesn't mention Meta at all. And there's a very big difference between saying that Meta is not bound and leaving that out of there. If you're going to interpret paragraph 7 to suggest that Meta's successors are not bound by the easement, then you've got a direct conflict between paragraph 4, which says that the easement runs with the land.
Well, Meta was both the grantor and the recipient of
Yeah.
the easement rights here.
Right.
And the easement was recorded in 2003,
Correct.
right? And so the world is on notice of these reciprocal covenants. And the idea is that there's an ambiguity because paragraph 7 doesn't mention Meta specifically. Have I got to where the core of your opponent's argument is?
Yeah, essentially, they have to argue two things. One, they have to argue that paragraph 7, by omitting Meta, means that Meta's successors and assigns were not bound by the easement. So first, they have to establish that proposition. We think that proposition is wrong, and that's why we're entitled to some judgment. But let's grant them that proposition. If you are going to assume that paragraph 7 says that Meta's successors and assigns are not bound, then you've got a clear conflict between paragraph 4 and 1. And paragraph 7, and that would be an ambiguity that would have to be resolved by the trier of fact. So in any event,
That's what I wanted your response to.
So we either have an ambiguity that requires a factual determination, or we have victory in favor of your client.
That's it. That's exactly right. So let's assume that paragraph 7.
There's nothing in the easement or anywhere else indicating that prohibits the transfer of rights over the Meta parcel. Is that correct?
That's correct. So let's assume that they're correct in their reading of paragraph 7 for a second. That's how we get to this ambiguity. So they say, oh, well, we can resolve that. First, we can resolve it by the canons of construction. All right, so they have 14 pages in their brief talking about how you apply these canons of construction in order to find this easement.
Well, they rely, and the court also relies on Mr. Stout's view of it, which is since he was the original owner of all three parcels, he's in a position to know that the paragraph 7 reads the way it does because he designed it that way.
And that was the other huge problem with this court order, is that there's lots of evidence to the contrary. So first, going back to the canons of construction, if it takes 14 pages to talk about why this agreement is unambiguous, I think that's a pretty strong indication that they've got a problem with their argument. But secondly, and this was the most serious problem with the court's order, if you're going to be relying on Stout's testimony, then there's no business granting summary judgment, because that was just one slice of a lot of evidence in this case. Recall that the drafter of this easement said exactly the opposite.
And would that, I guess this is more a question for your opponent, but the fact that the drafter says the opposite, doesn't that create a factual problem right there insofar as granting a summary judgment?
Right, I mean, absolutely. There was a whole bundle of evidence out there that would suggest that this easement was designed to run with the land. The purpose of the easement.
Well, the fact that it says it's going to run with the land is a really good start.
I think that is a very good start. But then,
Well, there's no question about the validity of the recordation.
No, there's no issues about
mixed
that.
up legal or anything like that.
Yeah, just a pure,
This would be an easement appurtenant.
yes, which means that in the very definition of an easement, it's an easement that runs with the land, it binds all successive sign. And specifically it says, and it doesn't matter whether it's even mentioned in subsequent conveyances or not. I mean, an appurtenant easement always binds everyone if it's recorded because it's there in the property right.
And since that's the case, wouldn't paragraph 7 just really be redundant? I mean, you don't really need, if this is an easement appurtenant, then paragraph 7 isn't necessary.
No, actually, I disagree with that.
Okay.
Because
Clarify that for me.
Grill and Marina can enforce the easement, but it wouldn't be clear that Grill and Marina's successors and assigns can enforce that easement. So what paragraph 7 does is make sure that not only can Grill and Marina enforce the easement against Parking and Maida and every other person that ever owns that property, but it's their successors and assigns can enforce that easement. So it's that paragraph 7 is talking about the rights of the folks that own the dominant interest as opposed to paragraphs 1 and 4, which talks about the impact of the easement on the subservient property, the classic appurtenant easement that runs with the land. So, the bottom line is the trial judge was wrong to grant summary judgment because, as I argue, there really isn't a conflict here. Paragraphs 1, 4, and 7 do different things, and so that we should win as a matter of law. But there's certainly no way that they can win as a matter of law because it's clear from the trial court's order and from their brief, no matter how they describe it, attempting to call it context or whatever else, the trial court resolved disputed issues of fact here. So the summary judgment has to be reversed as to the parking easement. Turning to the fuel issue, I think it's really important to understand exactly what's going on here. You've got the Grill and Marina parcels that are side by side, and they're both owned and controlled by this guy named William Stout, who is the mastermind of the development. So Stout's Marina property buys this fuel system, installs the fuel system, which includes the tanks and the lines, registers the ownership of the fuel system as in the Marina property. Marina pays for it. Marina operates it. Marina pockets the income for 14 years or more. Then Marina is sold to CRE, and as part of the sale, Mr. Stout, with his Marina hat on, says, by the way, Marina owns the fuel system. We are selling you the fuel system. It's SHM that ends up with the property having bought it from CRE. And now Stout comes out of the woodwork wearing his Grill hat and said, oh, by the way, even though when I was wearing my Marina hat, I told you that I was selling you the fuel system. Now that I've got my Grill hat on, it turns out that the tanks were at least partially on the Grill side of the property. And since me wearing my Grill hat, I never sold you the tanks.
Can we cut to the chase on this? Are there fact issues concerning, I mean, does this record yield fact issues?
Yes, absolutely. That's the first argument we're making in brief, is that there were fact issues on whether this property, the tanks were personal property or real property, whether they were personally or fixtures. And that's critical here because the entire basis of their argument was that you couldn't, you had to have a written conveyance from Grill in order to transfer the related.
And isn't even the configuration, this is probably a better question for your opponent, but isn't the configuration of and the placement of the components of the fuel system sort of the subject of a factual dispute here?
Absolutely, because the court's order in several places suggests that the entire tanks system and line system is on the Grill property. And that's just not the case at all. If you look at the diagrams, you can see where the property line is and part of the tanks. And certainly the superstructure around the tanks is on the marina property. So you've got that fact issue that infects the order to begin with. Then you got the fact issue about whether this is personal property or a fixture. The cases tell us, the Sears Roebuck case, we cited in our brief and several other cases, say that the question of whether something is real property or personal property is a fact issue. So that would have to be resolved by the.
Is there any question? I apologize. I'm not sure I saw anything in the briefing or in the record on this. Is there any argument on an easement by prescription or anything relative to the
No,
fuel
not a
tanks?
prescription. So different kinds of easements that I'm going to get to in a second, but focusing on your first question, yes, there were issues of fact that should have prevented summary judgment in the first place. And the second argument that we have is that this is just a classic case of estoppel. We showed in our brief that there are lots of cases that apply your typical everyday ordinary estoppel concepts to create interest in real property. And this goes back over 100 years. You've got the Kugler case that we talk about extensively in our brief, the Coram case, the Monell case. Those are all cases that create essentially a property interest by estoppel. The simple principle in these cases, and this is a principle that's in Florida law, it's a principle around the country, and we cited some of the treatises in the real property treatises that talk about this principle. But they basically say that if you own property and you know someone else is making a claim, you can't just silently stand by and do nothing and then swoop in later when it's too late and make a claim for that property. So we think the easy way to resolve this case, well, first is because there's material facts, summary judgment should never have been. But secondly, just standard estoppel principles apply to prevent the very unfair result that happened here. The third, and this is probably the most interesting of the arguments that we make, is this easement by implication. There's a venerable old property doctrine in Florida law and all around the country that basically says that when property is divided and sold, and part of that property has been subject to a historical use, that historical use, that right to use the property continues even after the sale. There are a couple of really good examples of that in Florida law. There's the golf course case, the Williams case, the sewer case, the Kermit case. That golf course case is a good example. Property is long used as a golf course. You need to get from the 13th green to the 14th tee, and so you have to go over some property. When the property was divided, somehow that property didn't go with the new owner. The court said that use, getting from the 13th green to the 14th tee, continues as an easement by implication. The sewer case is the same principle. So that's a concept that's been in Florida law for a long time. Now we recognize that this becomes a bit more complicated because of the Tortoise Island case, because the Tortoise Island case has very seriously confused the law in this area. We talk about that extensively in our brief, and there are several paths around Tortoise Island. First, I think you can dismiss Tortoise Island as dicta because Tortoise Island really wasn't an easement by implication case. In Tortoise Island, if you look at Judge Coward's dissent, which was later embraced by the majority, Judge Coward is all concerned about the fact that what was really happening was the court was enforcing an oral contract to allow these purchasers to have access to this canal. And Judge Coward was really concerned, rightly so, about the fact that you don't insert these sorts of oral agreements into real property transactions. But Judge Cowart completely overlooked was that this wasn't in Judge Cowart reaching the right result in that case went further than he had to do and started talking about the easements by implication, and he confused an easement by implication with an easement by necessity and conflated those two concepts, as you'll see in one of Judge Sharp's later opinions in the fifth DCA. The bottom line is he just seriously confused the law in the area, and so the question is how do you get around it? One, you can find that it's dicta because the Torres Island really truly wasn't an easement by implication case. Secondly, you can find that there is the absolute necessity that's required in order to support an easement by implication. Again, Judge Cowart confused an easement by necessity, which is an easement that grants you access to land, with an easement by implication, which is an easement that recognizes a historical use. You can find absolute necessity in this case if you just look at the use.
You're at your rebuttal time, you may use it how you choose.
All right, I'll just make one last point on that is if you disagree with me on whether there's a factual dispute on the fuel issue, and if you disagree with me that estoppel applies, and we're at the easement by implication, and you are concerned about Tortoise Island, then I think this is the absolute perfect case to certify that question to the Florida Supreme Court. You couldn't have facts that more directly would historically have shown an easement by implication. And so if we get down to that, our last gasp, we would ask your honors to go ahead and certify the question about whether there is, in fact, the doctrine of an easement by implication in Florida. I'll reserve the rest of my time.
All right, we have 4 minutes left. Mr. Morris?
Mr. Rennick with the last good morning, so I'll start with a good afternoon. May it please the court. The trial court's orders on summary judgment were based on a legal ruling. That legal ruling was whether or not SHM had legal property rights into adjoining landowners, grill and parking. And those legal rulings on the legal rights to the property were based on undisputed facts, both the plain language of the parking agreement from 2003, and then the fact that they could not establish a legal easement to use grill's property on which tanks do lie. There was not a need to address exactly where those tanks were, but there was a need to address that there had to be a property interest in order to access them.
Taking them in the order that Mr. Brennick took them.
Yes.
How do you explain, how do you get around, what do you do with the fact that this easement runs with the land according to paragraph 4?
Right, so let me talk about that because I'm not the person, or nor is anyone in my firm the person who came up with the boilerplate terminology. That was actually the lawyer who drafted it. He said, that's our boilerplate, that's an easement. And then let me talk about easement impertinence and easements and growth. Easements and growth have nothing to do with this case. They're easements without a dominant estate. They're like an easement by a Tampa Electric company, okay? An easement appurtenant, yes, runs with the land, but easement appurtenance, I knew I was gonna have trouble with these words. Easement appurtenance can end on certain happenings, transfers of property, not using it for a certain extent, whatever. So an easement appurtenant is, yes, technically described generally as in perpetuity, it's running with the land, but it can have a termination date or a termination event. And here, the way the easement was drafted was to say that the successors and assigns of Meta were not bound, the other two were. Okay, so the problem that I have with SHM's interpretation is, how do you read paragraph 7? How do you give that meaning? That's the problem the trial judge had. Because it says the successors and assigns of Grill and Marina bind and are benefit from it. And then it omits Meta. Now their point is, oh, it's an innocuous omission, or it didn't need to include Meta. It doesn't say
Well,
that.
isn't their point that Meta was the dominant estate holder for purposes of the easement?
the easements were reciprocal though. So that doesn't really work either, because these are reciprocal easements between the two. So
But at
I
the
don't,
time of the creation of the easement in 2003, if the easement inures to the benefit of the other two, of Grill and Marina, then how does that easement inure to their benefit if they don't have, if their rights can be terminated merely by Meta transferring into a different entity? I mean, they could have done that the very next day.
it's true, but they agreed to a document that said that. They agreed to a document that
But the
omitted
document also
the
says, but
burdens.
it also says it runs with the land. So isn't there at a minimum a factual determination that's required there?
I don't know that there's a factual dispute there, but there is, I think that's their fallback argument. Their first argument is, well, doesn't need to be included there. They didn't say Meta isn't included, but by omission under the expressio unius, you have to say, well, the omission is intentional. So what does that mean? So if I give that meaning and I say, okay, it says it does not burden, does not bind the successors and assigns of Meta. Okay, so now do we have an ambiguity between the use of word perpetuity in paragraph 1 and this paragraph 4 runs with the land, binds people who hold the land? And what the judge did was then turn to the canons. Superficially, yes, that looks to be in dispute. And so is there a canon that helps me resolve that without resorting to parole evidence, extrinsic evidence? And the judge said a few times in his order, I don't need to go to extrinsic evidence once I apply the canons. So that's where he started, and that's the proper thing to do. And that's where he came to the specific versus general canon. And the Kel Holmes case that we cite in our brief is exactly this type of agreement. Isn't
the inquiry though on this ambiguity, isn't it directed to the party's intent at the time the easement was made?
I think that what the case law says is if you can resolve, and it's not just the Kel Holmes, I think we cite the Excelsior, et cetera, when you can apply something like the specific versus general and resolve the ambiguity without going to intent, you do that because you're then sticking with what the parties wrote and the general ordinary principles. I think if you get to we can talk about the next step of if you believe specific versus general doesn't resolve it, then yes, then you go to the next.
And that's where we are. That's where I am.
Okay, that's where you are. Well, let me first say that the Excelsior case, the other cases that Kel Holmes say, once you apply the canons, if you can give meaning to both in the specific versus general, then you don't need to go there. And the reason for that is, again, the Kel Holmes case is sort of the.
But you're kind of going in circles now. Let's say the canons don't resolve it. There's a genuine ambiguity. The inquiry becomes what was the party's intent. And
Right.
you would agree with me, wouldn't you, that an inquiry into the party's intent is a factual question?
Not always, okay? Only when those facts are in dispute. And so I want to talk about what are the purported, evidence in dispute.
Don't you have a dispute between what Mr. Stout says the document means versus what the drafter says the document means?
No. And I would urge you to read what the drafter of the document says in his deposition. Because what he says is he's pointed to specific provisions and he says, yes, that says what it says, but I can't tell you what it means. That's a legal determination. And he's asked about intent and he said, my intent is whatever my client had. I don't have a specific intent separate and apart from what my client had. So he specifically said he was not going to interpret the agreement as a matter of law and that he couldn't speak to the drafter's intent. He had the intent that his client had. So there is actually not an ambiguity there. And what the point did, or conflict there, and what the court pointed out is this is a document that's signed, by Mr. Stout on behalf of all three parties. So he's the one competent evidence of intent. There's not going to be another person on the other side of this.
But he's also the most interested individual in giving his interpretation on what he intended. I mean, there's.
Understood. And again, if they had some other evidence to suggest that that's not what was intended.
But given the interpretation of the trial court, how does that give any meaning or effect to running with the land under paragraph 4?
So I hate to go in circles, but I am because of the specific versus general. So, and I want to use the Cal Homes example. You have a broad arbitration clause. It says all of the disputes under arbitration are under this agreement are subject to arbitration. Then 3 paragraphs later, you have the paragraph that says, if there's a default, the buyer can bring suit. Okay, so what they say is, yes, superficially, how can the buyer bring suit if everything's subject to arbitration? And that's why the specific versus general comes in. It's an established rule for a reason, because lawyers who write contracts are not appellate lawyers, and they write these broad boilerplate provisions, and then they tuck in the exceptions that are specific below.
So we're supposed to read the exception for Meta
Mhm.
into paragraph 7,
Into
that
there.
because by negative implication,
Right.
and completely resolve from your perspective the ambiguity of paragraph 4, which is a little more comprehensive and is a traditional run with the land, and does say this easement can only be amended by another writing and needs to be recorded, because that goes to what the world is on notice of with respect to these parcels.
But
And then we've got the 3 paragraphs of 1 with each of these 3 parties granting an easement. So it seems like for lack of a better way of describing it, the construct that you put together with paragraph 7 is sort of hanging on a really thin thread in the interpretive gestalt here.
Well, I appreciate that, but I think that thin thread is well supported by the case law, that, and when the canons apply and how you do that, so that you don't need to go to the extrinsic evidence. But I also think here that if you get to the extrinsic evidence, which the court said, I don't need to go there, but the context in which a development is made and the deeds are done is important, and how the parties act is important, and that's a secondary source to see if my interpretation is reasonable. And then what he found in the public records was the undisputed evidence in the public records that this was always intended to be a parking parcel, that it was going to be transferred in order for multi-million-dollar parking garages to be done, and that nobody would make common sense for you to find somebody to provide 2 other parcels free parking if you were intending to do that. And then that once those parcels were built, everyone acted as if the 2003 easement didn't apply, because it was no longer Meta's, it was a Meta successor and assign, and they licensed the parking garages to the very people who are subject to that easement. Brill had to pay it under those agreements, SHM had to pay, CRE had to pay. And actually, when SHM went to buy the property from CRE and it realized the licenses were terminable, it entered into an agreement with CRE for a conditional licensing easement on parking. And it said, in that agreement, we recognize that the parking is pursuant to the licenses. So for 10 years, the parties act exactly as the agreement reads, according to typical contract principles. And it's only after SHM gets their conditional easement, the licenses are terminated, that it then seeks what it could not get under the easement agreement for the first time. And none of its successors had sought. And indeed, SHM itself is not providing reciprocal parking under the terms of the agreement. And so all of that, this was one of those cases of contract interpretation where it all fit together, where if you applied the canons and you looked at it and you said, okay, the canons, if applied, do actually resolve the ambiguity. But just to be sure, let me see how the parties have acted. Let me see what the context of this was. Is that reasonable interpretation? And then the third layer of that is who can testify about intent. So are we going to have a jury trial where the only person who was present to decide intent says one thing and no one can say anything else, and everybody's acted as if the easements don't apply after the transfer away from Meta? And I do want to clear up one thing in case it comes up on rebuttal. There were conveyances of these properties, of the parking property, and they didn't refer to the 2003 easement.
Well, they wouldn't need to,
They
since it
didn't
was
need to, but
recorded.
they referred to others. And it's been brought up, well, there were these other conveyances, and those did refer to the 2003 agreement, but they were not the parking property. They were part of the parcels that were submitted or that were transferred that involved a marina route, which was still bound by the terms of the easement. So that, all that fit together, and there really wasn't a fact dispute, and that's why the judge explained, like, first I do the canons, then try to do it and resolve it on its face. And then when I look to the extrinsic evidence, there's no dispute that this is what was intended.
In paragraph 4 there, doesn't it say regardless of whether specifically mentioned in any subsequent deed or conveyance?
They do, and the only reason I bring it up is because SHM brought it up and said, oh, well, you specifically mentioned it after that. And the reality is it was specifically mentioned when it applied, but as these parking parcels, it was not. So I just want to make sure that's clear. There's not like a dispute there that we were acting in, as if we believed the easement still existed. It's about that intent, that extrinsic evidence of intent, right? The reason that I bring that up. So I want to flip to the fuel claims unless you have more questions on that. So I want to talk about the fuel claims, and I believe the word mastermind was brought up. And it's important because the claim here is an easement by estoppel, right? So if there's some unfairness, I need to address that right away. And so SHM bills itself as the largest marina operator in the world, and it purchases the marina, and it knows through due diligence that the tanks are not on its property. Yes, before this, 3 sister organizations on the same property, they never had to figure out where the tanks were. Yes, CRE purchased the property, and at the time it was effectively a deed in lieu of foreclosure, and they never figured out where the tanks were. And now SHM comes in and they know these tanks are not on our property. It doesn't matter, the trial court wasn't looking at where precisely are the tanks? What does that mean in the whole scheme of things? The trial court zeroed in, because this is what the summary judgment addressed, on what legal right do you have to access the tanks on another person's property? What legal right can you claim to store the petrochemical on Grill's property? Okay, and they had to have a property right, and that's what they pled. And so the judge says a few times in his order that that's what he's deciding. He's not deciding where exactly is this. He's not deciding Grill's claims as to whether, if they are on a property, what that means for Grill, who's going to pay damages, etc. He's looking at, do they have a real property interest? Because that's what they wanted. They wanted unfettered access to continue to use the tanks where they lay. And so the court focused in on that. And turn to that really quickly, because he says it a few times. He says, SHM seeks a reward of a real property interest, and that the issues before him are, do they have a real property interest based on express transfer of the real property, acquisition of the property by adverse possession, or by easement by implication or estoppel. So the issue here was, do you have a legal property right? And that's what the court decided. Everything else came after with the stipulated final judgment. And so where the property tanks were, what that means, that was not addressed by the court. It's not what is being asked to be reviewed. So let me talk about the easement by estoppel, because yes, estoppel can apply in land transactions generally, but what they wanted was an easement by estoppel, and the Florida Supreme Court has said you don't get easements by estoppel. And you particularly don't get any estoppel unless you can show reliance. And they can't show reliance because they knew the situation. They actually bargained to get an extra 500. First, they bargained to get out of the deal entirely if they couldn't get access to the fuel tanks. And then they bargained instead for a $500,000 holdback because they knew the tanks are not on their property. So there's no reliance. There's nothing that Grill did at that point to fool them. They did their own due diligence, rightly so, and they figured out what the problem was. So at that point, there's no equitable estoppel, and there's certainly no estoppel to get an interest in Grill's land. And the Tortoise Island case, the Tortoise Island case is a very short opinion, and it says the issue of law is whether an easement by implication from a pre-existing use requires absolute necessity. And the holding is it requires absolute necessity. And that was the problem for the easement by implication, because the Florida Supreme Court says you have to show absolute necessity, and absolute necessity for 35 years has been, can you use your land? Can you use your land? Not for a specific use, but can you use it? And they're using it. They've been using it as a marina. They operate other marinas without a fuel component. They have, there's evidence that you don't need a fuel component for a marina. So they can use their land, and they actually say in their brief, it's not that we can't use our land, it's that we want to use the tanks on your land. That's not what an easement by application is for. That's why you got the extra $500,000, so you could either negotiate that or find an alternative. You know, and I want to talk about what we do if it's not tortoise island. If the tortoise island test isn't the test, then what is a test? Because there's a lot of different iterations of it in the article that they cite too. Is it convenience? Is it the most convenient use, or the use that you wanted, or the use that you had before? There's a reason for the statute of frauds. There's a reason we require these things to be in writing, recorded, and so that they can be relied on. And this is exactly the case where you would want an easement by application. Because who's to take care of the tanks? Who's to be there if there's a condition on the property that threatens them? All those things that you would work out as adjoining landowners, you have to work out. You have to put it in writing. You can't just presume that you can get an easement for something. So for those reasons, we would ask the court to affirm, and that's it. Thank you.
Thank you. Response.
Much as they would like to run away from it, there's no question that the trial court resolved disputed issues of fact in connection with the reciprocal property easement. The trial court specifically relied on Mr. Stout's testimony and said it was credible. Well, you don't resolve credibility disputes on summary judgment. And I would ask the court to go ahead and look at the testimony of the draftsman. So 11-476 to 79. And the draftsman specifically says that he drafted this thing so that it would bind the successors and assigns of the Maida property. So the draftsman's testimony is directly conflicting with Mr. Stout's testimony. And it also, Mr. Stout's testimony conflicts with his conduct over the next 10 years, where he allowed the customers of Marina and Grill to park without any charge. It was only after 10 years that he had changed his mind, got his grill hat and said, oops, wait a second, looks like Grill didn't sell you the property. So we clearly have disputes of fact. And as to the subsequent conveyances, every single subsequent conveyance either says that it's subject to the reciprocal property easement, or it says that it's subject to all easements of record. And of course, the reciprocal property easement was an easement of record. So we've got the evidence of all the subsequent conveyances. We've also got the evidence of the purpose of the easement, which was to ensure that there was enough parking for everyone. So there was lots of facts that were resolved. You can't just look at one slice of the facts, say that provides the context for your ruling, and ignore all the rest of the undisputed facts. So then getting to the interpretation of this easement, paragraph 7 never says that the easement does not bind Maida's successors. All paragraph 7 says is that Marina and Grill's successors have the benefit of the easement and are bound by the easement. It doesn't say a word about Maida, so it doesn't create the conflict that they suggest that it creates. And if it did say that, then you would have this direct conflict between paragraph 4 and paragraph 7. It is impossible to have a document that says that the easement runs with the land and binds all subsequent purchasers on the one hand, and then have a paragraph that says, oh, by the way, it doesn't bind anyone if you sell it even once. Those two propositions are just directly in conflict with each other. I would ask the court to go ahead and take a look at their specific versus general cases, because they're really taking those cases and stretching them to the max. The Oscilla case and the Terra Nova case are two good examples of that. So the Oscilla case, you've got one paragraph that talks about the amendment of a contract in general. And then you have another paragraph that says, but if you want to make this kind of amendment, you've got to do X, Y, Z as well. You can reconcile those things. One of the paragraphs just creates a small exception to the other paragraph, and that's what the specific general cases all do. They look at it as a general proposition and a small exception carved out. That's certainly not what you have here. You would have, if you read the paragraph 7 the way they do it, a direct conflict between language that says it runs with the land, binds all successors and assigns, and a paragraph that says it doesn't bind successors and assigns. You can't reconcile that. That would certainly create an ambiguity. As to the fuel issue, counsel said that the Florida Supreme Court says that there's no easement by estoppel. I'm not aware of any case that says that. The case that I know of from the Florida Supreme Court is the Kugler case, going back over 100 years, that specifically applies estoppel in this sort of situations. So the Florida Supreme Court has never said there's no easement by estoppel. The last point I want to make is on reliance, because they're looking at the wrong point in time. Marina, the property was sold to CRE. And at the time the property was sold to CRE, Stout through Marina was saying, oh, by the way, all the tanks are Marinas and I'm selling you the tanks. That's where the estoppel applies. CRE, Mr. Stout through Marina and Grill is a stop from saying to CRE that you didn't buy the tanks. Then we get the benefit of the interest that was gained by CRE. So we step into CRE's shoes, which is exactly what Kugler says. It says that this estoppel principle applies, it also applies against your successor. So the fact that SHM knew of this problem when it purchased the property is completely irrelevant. The question is, was there estoppel at the time of the purchase of CRE of the property? And the answer to that question is absolutely yes. And we get the benefit of that. So for all of those reasons, we think that both of the summary judgments need to be reversed.
Thank you both. Very well argued, interesting case. Good seeing everybody live in person, and have a great day. We are in recess.
All rise.